Chapter 10, Assumpsit, Sec. 54. The purpose of the action of assumpsit. The action of assumpsit was for the recovery of damages for the breach of plural or simple contracts, either express or implied. It was the remedy upon all contracts not under seal, whether oral or written, that is upon that kind of contracts classed as simple as distinguished from special ties. The term plural or simple contract signified every contract not under seal nor of record, whether verbal or written. The action is thus named from the word assumpsit, which, when the pleadings were in Latin, was always inserted in the declaration, as descriptive of the defendant's undertaking. To maintain the action, it was essential that a relation of privity exist between the parties, though it may be either as matter of fact or implied in law. Though contract be the gist of the action, it was at times termed an action on the case, but in time this characterization ceased. Sec. 55. History of the action. The history of the action of assumpsit, one of the most useful of the common law actions, is interesting and instructive. It is remarkable that for such a long period in the history of the common law system there was no remedy for that large class of wrongs classed quasi-contracts. It is interesting history also to note the labored effort which was made in earlier common law to afford a remedy for the increasing class of wrongs redressed by this form of action upon the basis or theory that the injury was in tort rather than upon contract. It was by a strange and unnatural construction that the early English courts, slaves to form, reasoned that the failure to perform a contract constituted a tort, for which an action of trespass on the case would lie. Previous to the introduction of this action, the only action which could be pursued on simple contracts was debt when the amount claimed was certain, but the fact that trial by wager of law could be demanded in an action of debt, enabling defendant to embarrass plaintiff and defeat recovery, was a serious objection to that action. And then there was no remedy for the breach of a contract where the amount claimed was unliquidated. This action was an offshoot from the action of trespass on the case. For a time after the action of trespass on the case was created under the authority of the Statute of Westminster 2nd, it was the only action which could be pursued where a party had undertaken to perform a contract and imperfectly or negligently performed the same, causing damage to the other party. The action was called an action of trespass on the case on promises. The action, though recognizing the element of contract involved in the transaction, nevertheless sounded in tort. So far as concerns the class of contracts implied where deceit or fraud has been practiced, we can readily perceive the wisdom of characterizing such an action as a tort remedy, for indeed we are still inclined to complain of the fiction involved therein in order to afford the remedy of assumpsit in modern law. Prior to the 14th century there was no remedy for the non-performance of a contract, unless it was for the payment of a certain sum of money, when debt would lie. The theory of consideration had not yet fully developed, so that the action of trespass on the case upon promise was resorted to. The gist of the action is the fraud and delusion that the defendant hath offended the plaintiff in not performing the promise he had made, and relying on which the plaintiff is hurt. In that class of violations of contracts involving no appearance or elements of tort it was not difficult to take an advance step, adopting the theory of consideration, as in ordinary contracts, which was the final step to the modern action of assumpsit, which was first recognized in 1603 in Slade's case, 4 Coke's Rep. 74, 91, 95. After this decision it came to be more frequently used than the action of debt for the enforcement of money demands upon simple contracts. The tort characteristic was abandoned altogether, the action being classed, as indeed it was, as a contract action. Assumpsit was designed to remedy an innumerable number of acts where good conscience and right-doing demanded that when one has committed a wrong that he would undertake to make proper recompense therefor. It was designed to furnish a remedy for two great classes of rights, in addition to those arising from express written contracts not under seal, and express verbal contracts, to wit, where parties from their conduct have intended to imply a contract, and second, where parties do not intend to make a contract, but the law nevertheless imposes one upon them, upon principles of good conscience and equity. The action of case was the first one established under the Statutes of Westminster 2d. The action of case was a tort action, while the action of assumpsit was a contract action. It is rather peculiar that an action of tort should be turned into one of contract, be coming afterwards one where there was only an imposed obligation. The law first gave remedies for acts of malfeasance, and then acts of nonfeasance, that is, where one refused or failed to do a thing which he had agreed to or was bound to do. This included executory contracts not under seal, and formed the basis for the action of assumpsit. Then the next step was to establish the theory that such contracts were founded upon a consideration. Special assumpsit was formed for such matters. There still remained no remedy for the innumerable transactions where there was no contract or agreement between the parties. Such, for example, as services rendered without any bargain. Debt could not lie, because there was no liquidated amount, nor could special assumpsit, for want of an express promise to pay. It was in the year 1609 the case of Warbrook v. Griffin, 2 Brownell, 254, which established the common count of quantum meruit. This was where a horse was left with an innkeeper to be kept, and he stayed too long, till he had eaten out his worth. The innkeeper was bound to receive and keep safely, and it was right that the law should imply a promise on the part of the guest to pay what was reasonable. The tailor was in the same situation with the innkeeper, and his right to recover upon the quantum meruit was recognized in 1610. Sec. 56. The contract involved in the action of assumpsit. The contracts, breaches of which are remediable in the action of assumpsit, have been classed in ancient and modern law as quasi-contracts. They are either express or implied, and are supported by a consideration the same as all other contracts. They are contracts implied in fact, and contracts implied by law. The law implies obligations or quasi-contracts from the acts of the parties, although no inference of an actual contract could be drawn as a matter of fact. The hostile attitude of the parties to each other in many cases forbidding the existence of an actual aggregatio mentium. The theory of consideration first adopted in support of contracts was that some actual benefit must accrue to the party liable. This was so in the action of debt, harm or injury to the complainant not being sufficient to support that action. In the class of contracts implied in fact from the conduct of parties, the consideration is actual benefit to plaintiff, and the principle that some detriment or harm will operate as a legal consideration was developed in the action of assumpsit. Mere detriment to the promisee will not support general assumpsit on quasi-contracts, which rests on equitable grounds, and requires a consideration of actual benefits received by the promisor in like manner as in debt. On simple contract, some have attributed the origin of the principle that a consideration was necessary to support a promise to Watton v. Brinth, 2 Hen. 43b, in which the defendant promised to repair certain houses of the plaintiff, and neglected to do it. The plaintiff was non-suited because no consideration was stated for the promise. The first case in assumpsit decided in England was where a bailee was held liable on a gratuitous bailment. It was entitled Wheatley v. Lowe, Crooks James, 668, Keen's Cases, 210, 1623. It was moved in arrest of judgment because there was no consideration, it not being alleged that delivery was made to the defendant on his request, that the acceptance of the thing bailed for delivery to another was not of any benefit to defendant sufficient to charge him with a promise. It was ruled that the acceptance of the money, accompanied by a promise to deliver to another, was a good consideration. Sec. 57. The contract involved, continued. The implied contract invented in order to bring an action of assumpsit was a fiction, the gist of the action being defendant's promise. The distinctive averment in the declaration was the defendant's promise. In the beginning of the action the promise was an express one, but in course of time cases were brought to the courts, in which the right of action on the one hand, and the liability to pay on the other, depended upon a moral and equitable duty to the defendant, arising, not from any promise made by him, but from the acts, circumstances, and relations existing between him and the plaintiff. The obligation of the defendant and the right of the plaintiff were founded upon the plainest principles of justice. Instead of inventing a new action, and applying it to the new class of facts and circumstances, they applied the facts and circumstances to the already existing actions. Instead of inventing a fictitious element in the action, they added a fictitious feature to the facts and circumstances, from which the duty or legal right arose. The courts invented the notion of an implied promise, in order that the cases of liability and duty resulting from certain acts, omissions, or relations where there had been no promise, might be brought within the action of a sumpsit. Judge Metcalfe in his work on contracts says, the usual action on a simple contract in old times was debt. The declaration in that action averred in substance that the defendant owed the plaintiff, and thereupon an action had accrued. No promise was alleged, for no promise was necessary. But the defendant was allowed to wage his law. To avoid this wager of law, a new form of action was devised, to wit, the action of a sumpsit, in which a promise of defendant was alleged, and was indispensable. A declaration which did not aver such promise was insufficient even after verdict, and the law is the same at this day. The promise declared on is always taken to be express. In pleading, there is no such thing as an implied promise. But as no new rule of evidence was required in order to support the new action of a sumpsit, it being only necessary to prove the debt, as was necessary when the action was debt, the fictitious idea of an implied promise was introduced, and for the sake of legal conformity it was held, when the defendant's legal liability was proved, that the law presumed that he had promised to do what the law made him liable to do. Respecting this, Mr. Pomeroy observes, this origin of the implied promise, of its invention as a fiction in order to bring the case within the operation of a sumpsit, throws a strong light upon the question, whether, in an action to enforce such a liability under the codes, the plaintiff should, in addition to the actual facts from which the defendant's liability arises, also allege a promise to have been made by him. The promise was simply a formal incident of the particular action in the old system, and is certainly no more than such an incident in the new. Sec. 58. Two kinds of assumpsit. Assumpsit was divided into 1. Special assumpsit, and 2. General assumpsit. Special assumpsit later recover damages for the breach of an express simple contract. The action in this form was always based upon some express undertaking or promise to pay money, or to do or omit to do some particular thing. General assumpsit lay for the recovery of damages for the violation of implied simple contracts. General assumpsit is generally attributed to the case of Slade v. Morley, decided in 1603. Special assumpsit was founded upon an express contract. General assumpsit was a form of the action adopted in all cases where there was no promise in fact, being grounded upon certain facts happening or existing between the parties from which the law raised the implication of a promise. But whenever the promise was thus implied, it was declared upon as an express one, and upon the face of the record was always taken to be express. There was no such thing in pleading as an implied promise. Lord Mansfield in Moses v. Macfarlane, 2 Bur. 1012, 1760, said, if the defendant be under an obligation, from the ties of natural justice, to refund, the law implies a debt, and gives this action, founded in the equity of the plaintiff's case, as it were upon contract, quasi ex contractu apostrophe, as the Roman law expresses it. Sec. 59. General assumpsit. The common counts. The common counts in general assumpsit was the common law method of general pleading which will be explained elsewhere. It was pleading legal conclusions and not facts. Assumpsit was a concurrent remedy with case in many instances. The common counts were divided into 1. Indepitatis counts, 2. Quantum meruit counts, 3. Quantum vailment counts, and 4. The account stated. Indepitatis counts are subdivided into 1. Money counts, a. Money paid by plaintiff for the use of the defendant, b. Money had and received, c. Money lent, d. Interest due. Indepitatis counts, other than money counts were 1. Board and lodging furnished, 2. Goods sold and delivered, 3. Goods bargained and sold, 4. Lands sold and conveyed, 5. Work, labor and service, 6. Work, labor and materials. It would seem that as special assumpsit is upon an express contract, and general assumpsit upon an implied contract, the two forms of the action could not logically be used in the same action. But the practice of joining some one of the common counts in the action of special assumpsit became common. This practice is still pursued in the state of West Virginia, where in bringing special assumpsit there is usually added an appropriate common count. And it is held in this country that where there is a count on special contract and the common counts are used, the plaintiff may recover on a quantum merit, if he fails to prove the special contract, but not if he proves a different contract. Chitty says, though it is a rule that when there was an express contract the plaintiff cannot resort to an implied one, yet he may in many cases recover on the common count, though there was a special agreement, provided it has been executed or completely performed. The indebitatis assumpsit count stated that the defendant, on a certain date, was indebted to the plaintiff in a named sum of money, for use and occupation, for goods sold, for services rendered, for money lent, paid, had and received, or for some other pre-existing debt on simple contract, incurred at the defendant's request, and that being so indebted, the defendant, in consideration thereof, then promised the plaintiff to pay him the said sum of money on request. The quantum merit count, instead of stating that the defendant was indebted to the plaintiff in a certain sum of money, for work, and c, as in the indebitatis count, alleged that in consideration that the plaintiff, at the request of the defendant, had done work, stating the subject matter, he, the defendant, promises the plaintiff to pay him so much money, as he therefore reasonably deserved to have. The quantum vailment count was in general confined to the case of a claim for goods sold, and stated, that the defendant promised to pay so much money as the goods were reasonably worth, stating how much they were reasonably worth. The account stated alleged that the defendant on a named day, month, and year was indebted to the plaintiff in for money found to be due from the defendant to the plaintiff on an account then stated between them, concluding with an averment of a promise as in the indebitatus count. The indebitatus count was regarded as amply sufficient for all cases where the price was not fixed and certain. Sec. 60. Count for use and occupation. In view of the modern law touching the question whether a suit upon account for rent may now be maintained, or whether the action must be in the form of assumpsit for use and occupation, the common count for use and occupation is particularly interesting. Originally assumpsit could not be supported for rent of real property, though not reserved by deed, unless an express promise to pay could be proved, the demand, in the technical phrase, savoring of the realty, and being recoverable by debt or distress. The statute 11 Go. 2c. 19 was passed to remedy the common law in this respect, after which, rent due on admise not under seal could be recovered by action of assumpsit as well as debt. The common count for use and occupation thereafter became of frequent occurrence. Sec. 61. General assumpsit where there is a special contract not completely performed. The authorities are in conflict touching the question of the right of a party to recover in general assumpsit for part performance of an express contract. If he has failed to fully carry out and perform the express contract through no fault of his neglect or failure to discharge his contract being due to the wrongful conduct of the other contracting party, it would seem that the law would imply a promise to pay for the benefits received by the other party by a partial performance for which general assumpsit would lie. The rule is well supported that if plaintiff is prevented or excused from performing the residue, by act or consent of the defendant, or by the occurrence of any event by reason of which he is expressly or impliedly excused from further performance, he may maintain an action on an implied assumpsit for the reasonable value of the part performed by him, provided it has been beneficial to the defendant, and has been retained by him, and the special contract cannot be set up to defeat implied assumpsit. It must be observed, however, that the action in such case has no relation to the special contract, but rests upon another contract implied by law, from some fact or circumstance occurring independently and subsequent to the contract. The authorities sustaining this doctrine hold that the special contract cannot be interposed to prevent recovery.